Today I'm going to be speaking about settlement agreements, and in particular the ways in which they can go wrong, or some ways in which you might want to try and get out of them. I'm going to begin by talking about the way in which settlement agreements are construed by the court. Now, I'm not going to go into orthodox contractual interpretation principles. I'm going to look at some specific features that only really arise when the court is looking at concluded agreements. I'm then going to look at the uncertain but very alluring principle of sharp practice, and happily not something that we have a lot of in the Northeast, but how that equitable principle can be used to avoid a binding settlement agreement that would otherwise tie the hands of your clients. And then finally, I'm going to look at specifically settlement agreements involving land and dispositions of land, and how Section 2 of the Law of Property Act 1989 interacts with those agreements or doesn't interact with those agreements, as the case may be. So I'm going to begin by talking about interpretation of settlement agreements. And the reason I'm going to talk about this is that a problem often arises in that a new claim or a new allegation might emerge after an agreement has been concluded. And sometimes that's an allegation that wasn't known or suspected by one or both parties. That new claim could even emerge from a change in the law, and we'll look at that situation as well. It simply might not have actually been in existence at the point when the parties signed a settlement agreement with a big general release clause, as we all insist on doing pretty much when we settle things now. And two questions are then likely to come up in this context. One is construction. Does the agreement, on its true construction, preclude this new claim or allegation? And then, assuming it does, enforceability. If it is covered, is there any way that the agreement can be torn up or circumvented by the court? Settlement agreements are contracts, and save for a few odd cases, like Inheritance Act claims or claims under the Matrimonial Causes Act, they have contractual effect from the point of signature or agreement. Of course, Inheritance Act claims, MCA claims, they only have effect when they are approved by the court of the settlement agreements. That's the exception there. But two fairly obvious points flow from that. I'll go through these quickly. First is that you can set aside a settlement agreement for all the usual reasons a contract can be set aside: misrep, duress, fraud, etc., etc. And secondly is that the orthodox principles of contractual interpretation apply to settlement agreements. But in addition to the general approach that I've just set out, when a court interprets a settlement agreement, there are two extra considerations that will apply. The first is that the court will be very slow to conclude, unless there's very clear language indicating otherwise, that a party intended to surrender rights and claims that it wasn't aware of, or that it couldn't have been aware of when the claim was entered into, the agreement was entered into, sorry. And that is what gets called the cautionary principle, and it has its popularization, if not its genesis, in a case called BCC and Ali, a 2002 House of Lords case. And the second principle is that when we deal with fraud claims, because fraud claims are a thing unto themselves, unless there is very clear language saying fraud claims are included in this release, or when the context of an agreement makes that conclusion irresistible, the court will usually be pretty reluctant to find that a general release releases fraud claims. BCC and Ali, the case I mentioned earlier, remains really the leading case on the construction of settlement agreements. And in broad terms, this was a case which emerged from the collapse of the Bank of Credit and Commercial International Bank. Upon its collapse, it became apparent that the bank had been run in essentially a fundamentally dishonest way for many years. In 1990, about a year before the beginning of the end for the bank, it made 900 of its staff in England redundant. And the redundancy package included a release clause, and I won't read all of it, but the key part for our purposes are that the claims that are released are any and all claims, whether under statute, common law, or in equity of whatsoever nature that exist or may exist. And then, in particular, any employment tribunal-related claims. Now, after the collapse of the bank, a new question arose as to whether or not that clause was going to stop employees suing the bank for what we call stigma damages. That is to say, damages to compensate them for their disadvantage in the employment market that they had because of their association with this tarnished property. When the redundancy agreements were concluded, the reason this was an issue is that stigma damages were unknown in English law. Everyone had basically assumed that Addis Gramophone, a case that many of you will know, prevented those claims. That changed in 1998. The House of Lords, in a case called Mahmood and BCCI, said, no, you can't have stigma damages. So that is the staging for the claim in BCC and Ali. And the employees said, look, we can't possibly have sensibly been taken to conclude and settle claims which weren't even in existence in English law at the point of this agreement. We couldn't have known about them. The bank couldn't have known about them. And in a very strong dissenting judgment, which I would encourage you to read, Lord Hoffman said that no, these should be precluded. The language of the draftsman showed that they meant business and that they'd gone to some trouble to avoid leaving anything out. I think there's some force in that because it's hard to see what work the phrase exist or may exist is doing in that release clause unless it is anticipating the fact that there might be claims in the future which don't currently exist. But the employees made the argument I've already set out, and the House of Lords, the House of Lords agreed with them. Lord Bingham gave the leading judgment. It's set out in the handout. And the key part of it is really at paragraph 17. These authorities justify the proposition and provide not a rule of law but a cautionary principle which should inform the court of the approach to the construction of an instrument such as this, and that there was a reluctance to infer that a party intended to give something up which neither he nor the other party, and then this is the key part, knew or could have known that he had. So there's a duality there. One, did they know about it? Two, could they have known about it? I have some sympathy with Lord Hoffman's view. I've already said that. Why shouldn't parties, especially those who are advised by lawyers, be taken to understand that the common law revolves and that new claims might emerge, especially in circumstances when they've got an express term in the agreement which seems to anticipate that. But that was not the review of the majority. In contrast to the position in BCC and Ali, where we had a sort of unknown, the court does take a different approach when what you're dealing with is what they call a known unknown. And the relevant case that I've set out on the handout is a case called Leslie and News Group Newspapers Limited. As you can probably infer, that was a case about phone hacking, and it was brought by a former Blue Peter presenter, Mr. Leslie. The particulars of claim were drafted in terms that relied on certain allegations of hacking, but made clear that they couldn't possibly know or plead out the full extent of this intrusion into his private life until they had disclosure. Those proceedings were compromised, and following the compromise, a fresh set of proceedings were brought, essentially on the basis that new information had come to light. Previously, it had been limited to Glenmore Care. Everyone will know that name of a certain age, and actually it was much wider than that. For our purpose, it's enough to know that the High Court concluded that the terms of the compromise of the first proceedings amounted to a general release of all phone hacking claims. Okay? Mr. Leslie appealed to the Court of Appeal and relied on that principle we just talked about at BCC and Ali. They were claims that he didn't know about and couldn't have known about. And The judgment of the Court of Appeal is at page 22, but in essence, the Court of Appeal said, no, you did this with your eyes open, Mr. Leslie. You knew that there might be more claims that could emerge. These were known unknowns, and you didn't take the opportunity to go through disclosure, flush out those claims. Therefore, you are precluded from bringing them. So, in summary, what we have to be careful of, or what your clients have to be careful of, when they come to us and say, look, these new facts have emerged, would those facts have come out in the first claim? Would disclosure have revealed some of these facts? And if so, the court is pretty likely to say, and this again is really just harking back to contractual principles, it's a risk you assumed. They bought off that risk in this settlement agreement. I'm going to turn quickly to fraud. Fraud claims are a thing apart, as I've already said. That's the judgment, the often used quotation of Lord Bingham in the HIH casualty case. In essence, when you are looking to argue that a fraud claim has been released, the court is going to expect to see very clear language. So the standard, I'm just thinking of it because I settled a case about a week ago where the other side inserted this, the standard practical law release clause, off the top of my head, I don't think expressly mentions fraud. So fraud claims are unlikely to be released unless it's either expressly mentioned in the release clause, or fraud was just in the contemplation of the parties. Everybody, even if it wasn't a claim, it was a claim for breach of contract or a claim for deceit, say, and then what is later pursued as a conspiracy claim. If it was sort of in the ether that everyone knew about fraud and that this was a sort of fraud-adjacent scenario, you can sometimes rely on that context. But frankly, you don't want to find yourself in that situation. So if you want to exclude fraud, make sure that the contract specifically says so. 3 cases, Man and Freightliners, and Satyam Computer Solutions, both cases where a general release didn't release fraud. The contrast is the Chenges case, part of the long-running litigation with the Chenges brothers and their various financial institutes, where although it wasn't specifically mentioned, because there'd been lots of allegations of fraud in essence, even if they weren't being litigated at the time, a general release was taken to release them. Next principle I want to look at is something called the sharp practice principle. It's very alluring to lawyers because it offers potentially the way to get out of a release clause that otherwise would bind your client. And if the question is, can I get out of this? The answer is, well, probably not, but in certain circumstances you might be able to. And I'm just going to run through them very briefly. All of this traces back to the BCC and Ali judgment, and in particular the judgments of Lord Nichols and the dissenting judgment of Lord Hoffner I already referred to. They're set out again on the handout, but in essence, what is said is, their lordships had already concluded that a general release could, I've already gone through what the judgment concluded, but what they say is that materially different is where one party knows that the other party has or might have a claim and seeks to take advantage of that in negotiating a general release. And in certain circumstances, that party might be prevented from relying on that general release to exclude a claim that they knew about but the other side didn't. Now, Lord Hoffman's judgment suggests that you need a bit more of an active role of suppression in it. To my knowledge, this has never been successfully litigated on as an argument, but it's open-textured, there's uncertainty, and if you get home on it, it gives you a total, it will defeat what otherwise would be a total defense. So you can see why people try. What I'm going to suggest to you, though, is it's probably not a particularly wide exemption, and I would place a lot of caution before you rely on it. The case which I think puts the nail in the coffin is this case, Maranello Rosso. This case dealt with fast cars, which makes it exciting to read about. But in essence, a company called MRL purchased another company that owned a lot of very fancy cars with a plan to sell them individually at auction and make a profit. They entered into, with Bonhams, the famous auction house, an agreement whereby a third-party company would provide them with a credit facility that they could use to buy the cars, and then they'd sell the cars through Bonhams. Sales didn't go as they wanted, and they ultimately brought a claim against Bonhams. The pre-action letter contained lots of big allegations of breach of duty in sort of general terms and fiduciary duty, even if the actual claim was centred on negligence. They settled those proceedings, and then subsequently, MRL tried to sue for a claim that it said wasn't covered, which was a claim in unlawful means conspiracy. That was dismissed by the judge at first instance, and the MRL appealed to the Court of Appeal, relying on the sharp practice principle, and saying essentially, they knew about this, we didn't know about this, they've taken advantage of us, we shouldn't, if we accept we've been held that this was covered, we shouldn't be held to it, because of equity should intervene. The Court of Appeal disagreed for two reasons. One is a fact-specific reason, which is MRL was aware of these sorts of claims. That was clear from the letter before action. And so it had assumed the risk of not fully investigating those claims. But the second point, and I think this has been underreported, but is probably very significant in narrowing the ambit of this sharp practice exception, is this. By the time the court has concluded that a settlement agreement does release the claim that you're trying to bring, it's necessarily, as part of that construction, decided that you mutually intended to settle those claims. In reality, because the court's already concluded, yes, this was in your mind from an objective point of view, and you meant to settle those claims, really, what's the scope for equity to step in there? I mean, you're just getting what you bargained for. And so I think it is only going to be in a case where you could show some really active suppression of facts where this would be a runner. I'm going to finish up by talking quickly about this provision, Section 2 of the Law of Property Miscellaneous Provisions Act 1989. It's an often misunderstood provision, and it's sensible just to begin by looking at the text. A contract for the sale or other disposition of an interest in land can only be made in writing and only by incorporating all the terms that the parties have expressly agreed in one document, or where exchanged in each. And the problem with this, from a drafting point of view, is it seems to suggest that there are two agreements. There is the agreement that you actually reached, and then you cross-check that, the oral or parole agreement, and then you cross-check that against the written agreement. And if they don't match up, then the written agreement is unenforceable. And that basically just invites parties to go rummaging around, looking for some spurious term that was part of the oral parole agreement, but hasn't made it into the final contract or settlement agreement. And this is a very popular way of trying to avoid settlement agreements. There's a purchaser. They agree to buy 11 flats on the quayside, or an option to buy, from a vendor. And they agree, we're going to have a fixed price and we're going to have the right to assign those contracts to third parties. They also agree that the vendor will pay the purchaser a finder's fee of 2% whenever the contracts are exchanged, whether with the purchaser or their assignee. By agreement, because the purchaser, who's buying the options, wants to be able to assign the contracts but keep the benefit of that finder's fee clause, they don't put the finder's fee in the contracts for the sale of land. Otherwise, they're all kosher, signed, etc., etc. Having just seen, and on the handout set out, how Section 2 of the Law of Property Act works, in your view, would that be a void option or not? And the answer to that is yes, it is valid. I'm not going to go through it in any detail because we're running over on time, but there is a local case called Northeastern Properties Limited in Coleman, where basically this exact issue came up. One of the key quotes is there, it's no part of Parliament's intention to make it easier for people to escape settlement agreements. or contractual obligations, even though, as the Court of Appeal acknowledges, that's actually what Section 2 does. And in essence, it all comes down to how you structure your agreement. And the key takeaway here is dependent and independent clauses and agreements. If the promise to transfer the land is dependent on something else, that was part of the land contract. And all of those terms have to go into the settlement agreement in order for it to be effective at law because of Section 2. If it was an independent obligation, which it was in this case, then you won't need to put it in. And in this case in particular, the use of an entire agreement clause was very useful because it signaled to the court, no, this finder's fee agreement was a separate thing, a thing unto itself. In essence, in this case, roller team. There was a big family Barney about a company that runs, amongst other things, or ran a Sherlock Holmes exhibition on Baker Street, a museum. And they all got together and they they came to terms in writing. And those terms were never signed, but what they said is, this sister is going to declare certain trusts, and in return, the brother is going to pay the sister a few £1 million, or the siblings. It was never signed, though. So prima facie, you might think that was invalid. What happened in that case is the sister did declare the trusts, went along a week later, declared the trusts, and then sued. And the brother said, well, sorry, I'm not paying you the money because it was a void contract. And the distinction that the court drew was this. This was not a contract for the disposition. It wasn't a promise to dispose land in return for another promise. In effect, it was a unilateral contract. And the contract only formed when the sister transferred the land. So it's like me saying, if you find my cat, I will give you £100. If you turn up to my house with my cat, I'm now obliged to give you £100. And so because it wasn't a contract for the promise of disposition in land, but rather was a contract which affected a disposition in land, seems like a narrow exception, but it is an important one, it wasn't caught by Section 2.